by the way, you don't know in the state of Florida, a perjury conviction can get you 5 years in prison. So I wouldn't even be here today. I self-represented and the case ended when the judge was sent in from another circuit by the Florida Supreme Court. And he dismissed the case after about an hour of time. But it took me disqualifying several judges in 7 months of being prosecuted and bouncing from courtroom to courtroom and from judge to judge. And throughout this criminal proceeding, I requested documents from the city that I was entitled to as a part of break. So recently I put in a request for that same information and I get this invoice for $10,614.50. And you all, the city, is claiming that somebody needs to put 461 and a half hours toward finding what you should have had when you were prosecuting. So I don't think anybody here believes that it should take any one person or any combination of people essentially 12 hours a week time, of working time to give me the information. In fact, you're going to give it to me because I'm entitled to it under Florida law. And you can just go to check out Chapter 119 of the Florida Statutes or Sunshine Act. Plus, our governor's already put on the record that Florida is a law and order state. Not
I don't like Ron DeSantis. SEC that you can kiss my ass.
Legislature is putting in place.
Oh, okay.
So I'm here hoping that I can convince you all to get whoever is responsible to get me the information I requested. And I shouldn't have to do some sort of GoFundMe to have the city do what it's supposed to be doing. So I appreciate your time and hopefully you take me seriously with what I'm asking for. You all take care.
That's Tampa City Council for those who don't know. They're gonna start talking about me in a second.
Mr. Mass, are you familiar with what this gentleman was talking about, sir?
So this is a city attorney coming up now.
I'm not familiar with the exact items, but under state law and we under our public record, we have a public records office, and we do charge for staff time if it's for extraordinary requests that require additional special type of services and trying to retrieve all the records. So that is standard operating procedure, and we are allowed to do that under state law. There's cases where that's been challenged before for other municipalities, and the courts have upheld that our ability to charge for those sorts of services.
So here's where I would, if it weren't for the fact that they prosecuted me and this information, I find out only when I started my civil lawsuit that you had this information while I was being prosecuted. My argument is, well, if it existed then and I requested discovery, which I did, and I was told that you'd give me everything, that's a lie. This is still Brady information because there's probably information in that I could argue that there was information in emails that was either exculpatory, which would have exonerated me, or inculpatory, which would have led to me being able to be convicted, which would have probably led me to once, okay, if you had any information that was inculpatory, okay, I may want to plea out to something lesser or whatever.
Well, it's most likely not there, yeah.
Listen, we can imagine how many niggas I was in them 7,000 emails. Okay. Yeah. By the way, anybody who doesn't think there's something strange that they would have 7,000 emails on some regular guy, that should be making everybody's antenna go up. Why would you have 7,000 emails on this guy if he's not somebody to be concerned about?
So is that attorney? So Tampa has the different prosecuting attorney versus this attorney that was just speaking at the
because I'm suing the city. Remember, the city's named in the lawsuit because it was the city's police officer that falsely accused me, right?
Well, that's not the prosecuting attorney, right? That's just the city's attorney.
No, that's the city's attorney. The prosecuting attorney, once the case was dismissed, it was dismissed.
Well, I'm saying, so like in Washington State, the county's attorney is the prosecuting attorney.
Right. This is the city's attorney. I was prosecuted by the county. The 13th Judicial Circuit is Hillsborough County is the state of Florida. So the state of Florida prosecuted me. They charged me with felony perjury in an official proceeding. under
Mhm.
state law. That has nothing to do with the city. When I
But
sued,
it was the city police that the judge called, right? That's how that they
right,
got
and
connected.
because
Gotcha.
it was the city, the county, which is the sheriff, and all the entities that they were communicating with, I'm entitled to all of it. And plus, you can't hide it and charge me because it's all public information. Remember,
Should
it's
be.
you can't use it as it's not work product because it belongs to the public.
Should be. Should be. That's
If they use city equipment or city emails, it belongs to the city.
should be.
No, well, they should, yeah. And I'm pretty
Should
sure they
be.
probably found a way to get rid of it, which would be an inference that you knew there was something
A
that would
little
have
funky going
benefited.
on.
But listen what he says now, and then you're gonna have this burly chick come running out here to the front. Watch this.
If I may.
I can't let you speak.
I didn't have any more time left.
Mr. Massey, and I understand all those rules. My concern is if there is a public record and police arrested people or did anything to this gentleman from 2017, in my mind, there should be already records held already and not.
All I can do, I'm not familiar with this in particular. All I can do is we will look into it. And we'll have
You
public
just
records office.
information because I see something wrong here. I understand how sometimes we become victims when you have a certain kind of skin color. I hate to say that, but the bottom line is I want to get this information. I'll probably be gone, but I know several colleagues will be here, and that needs to be looked into because you can't tell me I'm a police officer a long time. They keep records. So gentlemen, give her your name, sir, and hope we can address that.
Watch this.
Thank you. Do we have anyone else in chambers?
Watch this.
Mr. Massey.
Mr. Good's question, Ursula Richardson, who's in charge of our litigation department, this matter is an active litigation. I think she wanted to let you all know that this is standard operating procedure.
Watch this BS. Some of it's BS, but listen to this shit.
And just so that you are aware, this is a federal lawsuit that's in front of Judge Charlene Honeywell in federal court. We are in the discovery process, and as a part of the discovery process, you can't just get free records.
Now, this is what's interesting how she wants to characterize free records. That the issue is you all did turn this information over during my criminal case. And by the way, the interesting thing about Judge Honeywell used to be the chief judge of the 13th Judicial Circuit and I have 6 judges on my witness list that she at one time worked with. So naturally, she should have recused herself from my case.
Mhm.
But she kind of told held the water for him, and she shut down my entire discovery. So just shortly after this, she shut off my discovery. So I didn't even get discovery in my civil case. Part of my argument in the 11th Circuit Court of Appeals, because even if you wanted to argue that Holder had absolute immunity, the city doesn't acquire absolute immunity because he made a false allegation. The city still had to have probable cause to even arrested me. No probable cause exists, as we all know if they watched the whole perjury thing, because I didn't do anything that they claimed I did. So there was no probable cause or even arguable probable cause.
Mm-hmm.
So, but listen to what she said. She actually gives me a compliment in here after she finishes bullshitting.
So if it's going to take any extraordinary amount of time to get the records that Mr. Doss is asking for, and I haven't looked at his new request, he sent a public records request first when he should have been operating within the confines of the actual lawsuit itself, the discovery rules.